with a continuation of my promised videotapes about shenanigans at the courthouse in New York. I would like to speak to all of you today about referees. I don't mean referees in boxing rings, I mean referees in the courthouse. If you don't know, referees are appointed by judges when judges are too busy to hear various matters involving the case that they're assigned to. They then assign them to referees to hear and report. I have a situation that I think all of you should be aware of. Resourceful Joe Burke, who secreted a note of issue in March of 2006 and didn't bother telling anybody about it. And if you don't know what a note of issue is, it's usually filed when a case is ready for trial. It's called a note of issue and certificate of readiness. Resourceful Joe Burke filed one in the case that I'm involved with him and his client in March of 2006. Didn't tell anybody about it. I didn't know anything about it. Judge Stallman issued an order in 2008 February appointing yet another referee, Referee Jack Souter, to supervise discovery. Now, when a note of issue and certificate of readiness is filed, all discovery ceases. It's illegal to have any further discovery. In order to try to have further discovery, you're supposed to make a motion saying, I want more discovery on an emergency basis. None of that, of course, happened. Referee Jack Souter was appointed. There was a meeting with Jack Souter on one or two occasions to discuss discovery that was already barred. Tax returns were produced by me that was illegally to have produced because they shouldn't have been produced because it was barred because the note of issue was already filed. Jack Souter didn't bother looking in the file, and Jack Souter knew or should have known a note of issue was filed and continued to conduct discovery. In June of 2008, Jack Souter was advised that I was going to California for medical care and that the email address he was using to communicate with me, because he insisted he had to communicate only by email, was being closed down because the company that I was using was accommodating me. He was told that by email, he was told that by phone, and he was told that by handwritten letter. Undaunted, Mr. Souter and Mr. Burke continued on ex-parte communications from June through September. And on September 10th, Mr. Souter, in his infinite wisdom, when I did not appear for a meeting that was supposed to be held in his office, all the while discovery was stayed because a motion was pending to remove this man. And why did I make that motion? I made that motion because Jack Souter spoke to me on the phone, and that phone conversation was transcribed. The essential elements of that phone conversation is, Mr. Couri, why don't you pay this guy something? Pay him $1 million or $2 million. You can afford it. You have $5,000 suits. You spend $100 for a haircut. Just pay the guy so he gets off your rear end. And I said, Mr. Souter, I don't owe the man any money. He owes me money. Well, you know, in these courts you can lose no matter what happens. Well, I should have analyzed what he was trying to say. Now I have. Going back to September 10th, Mr. Souter writes Joe Burke on his email and says, I'm sitting at my computer getting ready to nail Couri in words or substance. In response to Mr. Souter's email inquiry, Joe Burke writes an order and delivers it to Mr. Souter via email. Mind you, Joe Burke knew that all of these antics and shenanigans were precluded by the virtue of his secreted note of issue. But resourceful Joe Burke doesn't mind that he's disobeying the law. Resourceful Joe Burke doesn't mind that secreting a critical document such as a note of issue is referred to as spoliation, which also happens to be a crime. Writes Jack Souter, saying that everything should be resolved in their favor, plaintiffs should be precluded from offering evidence at a trial, and plaintiffs should then thereby be sanctioned. And Mr. Souter goes one step further and writes an order and files a judgment against me for $7 million. All the while, Joe Burke knew that all of these activities were illegal, and all the while Souter knew or should have known as a representative of the court that his activities were also illegal, because referees do not get appointed to conduct discovery that is barred and precluded by a filed note of issue. Now, fortunately, my friend, who no longer was receiving emails, somehow or another, these emails went into his garbage dump, and he was able to retrieve them. So we have all of them. Now, referee Souter claimed that he had no idea that there was a stay in this matter. There was a stay because, although I didn't know of a filed note of issue, I made a stay to preclude Souter from continuing his activities because of the manner in which he spoke to me over the telephone, telling me that I should pay up or I can lose. That's hardly the way an unbiased referee is supposed to conduct himself. Making matters worse, I made 2 motions before Judge Stallman to do something about this. Both of those motions were essentially ignored. There is something drastically wrong going on in these courts, and therefore I urge all of you who have the opportunity or the misfortune of going into Supreme New York and having the ability to go before a referee to please be sure that you have all of your ducks in a row. And please be sure that you keep all of your papers in order. And please be sure not to trust your adversary. Joe Burke is a licensed attorney. Joe Burke is bound by the rules of professional responsibility, and Joe Burke has violated all of them. The disciplinary rules are vast. There is a simple disciplinary rule, DR 7102, that tells a lawyer what he should and shouldn't do. Joe Burke has violated all of them. I respectfully point out that all of us going into court should stay away from resourceful people like Joe Burke, because they will do anything and stoop at any level to steal your money. I thank all of you again for the opportunity listening to me for the past 5 or 6 minutes, and I promise I will be back again. Thank you so much.